I want to buy a goose. About 5 and 8 pence.
Certainly, sir.
Roast beef.
No, try again.
Veal.
No, try. No, ribs. No,
I know. Sausages.
no, goose.
Like you, be strong to hold the powers of the sun.
I show you how deep the rabbit hole goes.
Listen to Pavarotti.
Can I be your superhero?
Hello, welcome to The Revealing. I'm your host, Pavarotti, and I am here to discuss the Idaho 4 case. And I feel bad for a lot of people out there that I even have to do this video because it's going to hurt some feelings. It's going to hurt some feelings really bad because the judge issued the order, several orders, but because the judge, thinking that he was being so thorough for the state, he just went in there and put some information that is not speculative. He put actual information in there, hard evidence, and he was just a little bit overconfident in what he was stating. He has inadvertently just destroyed the state's case, and I'm going to show you that in this video. I now can prove it beyond a shadow of a doubt. I mean, it's mathematically impossible. I'm going to give you hard proof that will impeach the roommate's statements. It will prove beyond a shadow of a doubt that what I have presented to you about these roommates is 1,000% accurate. That, well, I'll say about 98% accurate that the BF was not there. She wasn't there. But it's 100% accurate that what I've said about DM not being there until 4/19, I'm going to prove it in this video. The judge accidentally gave us too much information. I mean, these are hard facts I'm about to give you. The goose is cooked. And, you know, when I say I feel bad for some folks out there, I just spent an hour and I don't know how long minutes watching the interview with the drunk turkey and Mr. G. Now, normally I wouldn't let something like that focus my attention that much. And I've said this from the beginning. I mean, I feel for Mr. G. I feel for all of them. I mean, they lost a child. I mean, I believe me, that does not miss me. Okay. But I learned a lot of things listening to that interview. And unfortunately, I didn't learn the things that I spent my hour and ever how long minutes waiting to hear, I never heard. And one thing that I've said consistently, and he knows it, because he watches probably every video. I know we exchange comments every now and again. And during his interview with the drunk turkey, I mean, you can bet anytime he was talking about KOHBERGERs out there that create narratives, I mean, he's talking about Pavarotti. There's no doubt about it. Now, one thing he said was, you know, I hope I never run across him because he would go to jail. Well, I can appreciate you having that kind of frustration against me because I am absolutely advocating the opposite of what you're advocating for, but I'm not doing it for any other reason other than it's the right thing to do. And I've told other people this in the past when they've made statements like that. I mean, I wouldn't, if that ever happens, if that day ever comes, don't worry about going to jail or anything. That shouldn't even be a concern of you. The hospital, that would be your concern, I assure you. But I would hate to even, have it go there. The other thing that I learned, though, is in an hour and never how long minutes on a small content creator's channel where you had every opportunity to answer the two questions that I asked. I mean, I asked you to answer two questions only, and it would have a big impact on how I come at this case. And in all that time, you couldn't answer those two questions, and you knew what they were. How long have you actually known Carrick Kernodle, and were you aware of what was going on with Mr. Mogan? You just never did go there. So I'm sorry, but I'm really going to hurt your feelings in this one, and not in a direct, let me hurt your feelings way, but I'm going to hurt your feelings in a way where I'm going to show the world real hard evidence that disproves a major portion of the case. Like you said, DM plays a huge part in this case, right? I mean, a huge part. So what are you going to do when that huge part is turned upside down, discredited altogether, and the truth comes out about what truly happened in that situation? Because you're going to need to face it. Because I'm going to show you in this video, and this isn't me making up content and trying to bend things. I'm going to show you beyond a shadow of a doubt what the judge just put in the order actually showed us. And I'm probably the only one out there that can actually do this. So, folks, you need to hold on to your hats. In this one, we got the new order from the judge. It was very biased towards the defense, but inadvertently what he's done is disprove the state case. And I'm going to show you in detail in this video. Don't worry, we're going to get it out in this video. And by the time this video is done, all of you out there that really want the truth, you're finally going to have it. Let's get right into it. Now, what I'm going to ask you to do, and I've never done this before, but I've never done a video quite as important as this one, because this information, people have to understand, the light bulb has to go off, because it's true, hard evidence that disproves the state's case. So you've got to get this. Don't let it just kind of go over you as, oh, well, that's a good, idea or anything like that. I mean, this is 2 + 2 = 4, y'all. So I'm going to ask you to get you a piece of paper and a pen or pencil and write this down. Just a few things we're going to be going over here so that you can see in your own math how this actually disproves the entire testimony of the roommates. And it proves that what they're saying happened did not happen. And normally when we get these new docs, I like to go through and break them down for you just to report on them first before I give you the evidence that it shows in an investigative stance. But I can't wait to get this out because it's too big. So this is the new order from the state, from the judge, on the motions in limine regarding the text messages and the 911 call. Before I dive into this, I need you to clearly understand this point, because some people are going to try to rationalize in their minds that the reason that DM is spoken of so prominently in this and BF is ignored is because DM is the only actual witness to anything. And I'm going to negate that before we even get into it, because this is on a specific motion in regards to text messages and 911 call, and it is for the state to enter as evidence using legal terms like present sense impressions, and what was the other one? Excited utterance of actual calls, texts, and statements of not just DM, but of both DM and BF, and they want to enter the couple other people, Hunter and his girlfriend. But they are absolutely trying to enter statements of DM and BF as excited utterance or present sense impressions. So when we go through this, the absence of BF and the lack of attention to what's going on with BF is absolutely, no, there's no way you can disregard it because of what is being asked for in the motion. And that's to equally enter their phone calls, texts, and statements during the 911 call, and their testimony as well from the grand jury. And just to double up on that, let me show you the end down here when we get to what the judge actually ordered. So some of these he ordered that they could not be entered into evidence. Really, the most important ones he ordered that could not be entered into evidence. So this is not just a total loss for the defense. He did not admit into evidence the statements regarding the person in the house at 4 a.m. on the 911 call. And that was what the state really wanted entered into evidence because they have the finish, but they don't have the start time entered. So the two that the defense really wanted to be kept out were kept out. So that was kind of big. But where is this at? Where I can get this? Okay. All right. So just to give you an example of why BF and everything around her is just as important as DM in this document. And when you see how the BF was ignored on all of her stuff, there's no way to rationalize it in law for sure, but there's no way to rationalize it in your mind either. Because when it talks about the initial statements, the 911 call begins with BF telling dispatch, something's happened in our house, and we don't know what. And you can see the judge says this statement falls squarely within the present sense impression exception, given that BF was experiencing concern that something was wrong with her roommates. So this exchange is not offered for the truth of the matter asserted and therefore not barred by the hearsay rule. So he's actually entering in this particular statement of the 911 call from BF as not barred by the hearsay rule. So to say that they're not focusing on BF in all of this document because she wasn't a witness is not a rational argument. That's not real. It's just as much BF as it is DM in this motion. So when we go through this and we see how BF is removed completely, it should tell you the truth, which is BF was not there. But that's a side note on BF. I want to get to the actual proof of the matter that turns the state's case into mush. And you can see this introduction. This is supposedly written by the judge who thinks he's got a good grasp on the evidence. And I got to tell him he doesn't. But regardless of his grasp of the evidence or not, when he puts in certain things that are factual evidence, that can't be, it can't be argued one way or another. It's just facts. Then it's all over but the crying. But DM and BF are two surviving roommates of 1122 King Road. At the time of the homicides were believed to have occurred, DM saw a masked intruder in the house and began calling and texting the other roommates, including BF. Approximately 8 hours after DM saw the intruder, BF called 911 from her phone. So that's the overview. Now, when we get down here to where the judge starts talking about facts, though, that's where it gets really interesting. This is where you need your notes. Facts. Now, these facts that the judge are going to go through are not accurate. I'll tell you that first of all, but some of the things that he discloses, it doesn't matter about his accuracy. It's facts in the case. And it says, after spending the evening out, roommates DM, BF, Kaylee, and Maddie returned to their home at 1122 King Road in the early morning hours of November 13th, 2022. First of all, the judge doesn't even know the names of the victims. He called Maddie Madison Morgan. If that's not disrespect, I don't know what is. But the reason I want to point out this first statement is because when the judge outlines who he's speaking of when he says roommates, he's not just talking about DM and BF. When he states roommates, he's talking about DM, BF, Kaylee, Maddie, and the fifth roommate, Xana. So when he refers to roommates, he's not just referring to these two. He's referring to all five of them. So at approximately 2 a.m., they met up in Kaylee's bedroom and talked for a while before going to bed. Now, how interesting is this? If the judge is actually right on what he's saying here, they all, when he says the roommates, he's talking about in this particular statement, DMBF, Kaylee, and Maddie are all in Kaylee's bedroom. Now, we're told that Kaylee and Maddie are found in Maddie's bedroom unalived, yet they're all up in Kaylee's bedroom having this conversation, and Kaylee's bed is twice the size of Maddie's. So what would make Kaylee and Maddie leave Kaylee's bedroom with the big bed and go get in Maddie's little bitty bed in her little bitty bedroom? Maybe Murphy, I don't know, but I thought that was very interesting, if it's even correct, because he gets so much wrong in this. And it says they talked for a while before going to bed. So this was 2 a.m. The fifth roommate, Xana Kernodle, who was out with her boyfriend, Ethan Chapin, was not home yet. Now, I don't know if the judge realizes it or not, but if he is correct and this is the truth and this is 2 a.m., well, then he just absolutely destroyed the probable cause affidavit in this case. Because if Xana Kernodle was out with her boyfriend Ethan and was not home yet at 2 a.m., and that's accurate, well, Judge, the PCA lied, and that is a undeniable fact. Because you can see right here in the probable cause affidavit, it says DM and BF both made statements during interviews that indicated the occupants of the King Road residence were at home by 2 a.m. and asleep or at least in their rooms by approximately 4 a.m. So what you're saying is either law enforcement has lied in this statement or DM and BF have lied in this statement, but it's either them or it's them. And if you've got other statements now from the grand jury that states otherwise, well, then I think somebody needs to figure out who lied. Was it law enforcement or was it DM and BF? Because Judge, according to you, one of them absolutely did. DM and BF both made statements during interviews that indicated the occupants of the King Road residence were at home by 2 a.m. Occupants, that means all of them. With the exception of Kernodle, who received a DoorDash order. I mean, come on now. So when we go back to this, the fifth roommate, Xana Kernodle, who was out with her boyfriend Ethan Chapin, was not home yet. And we're talking about 2 a.m., well, then you just proved that somebody lied. If your statement right here, if that's correct, and that's from the grand jury like you say it is. So there's number one. He either discredited the PCA, absolutely, but he either discredited law enforcement or he discredited Dylan and Bethany from that statement. Now, the roommates debated. Now, when he says roommates, remember, he's not just talking about DM and BF. He's talking about the roommates who he said was home at 2 a.m. and everybody was home according to him other than Xana and Ethan. So when he says roommates, he's talking about Dylan, Bethany, Kaylee, and Maddie. So the roommates, Dylan, Kaylee, Bethany, and Maddie, up in Kaylee's bedroom, debated going out to a food truck for a late night snack. Well, Kaylee and Maddie just got home from a food truck getting a late night snack. And we all know, we watched it on video, that, not 20 minutes prior to that, they were chomping down. So I guess what they're trying to say right here is Kaylee and Maddie were on some kind of sumo diet where they got hungry every 15 minutes. So that is very suspect. I believe the way you could interpret that is Kaylee and Maddie had already eaten. They were already home. They were discussing going out to the food truck. So that could only mean Dylan and Bethany, if Bethany was even there at this time, were debating going out to a food truck for a late snack. And it says prompting DM to send a text at 2:10 a.m. Now, the way that we have to do this to keep everything extremely accurate is we have to go, let's see, where is it at? To the defendant's objection to the state's motion in limine, and use the text message and testimony that the defendant provided, because it was the exhaustive list, not the one the state provided that cherry picked. So when we cross-reference everything at 2:10:29, DM sent the text to EG inquiring if he was driving. Well, when we go back over here, we can verify this. The roommates debated on going to the food truck for a late snack, prompting DM to send a text at 2:10 to an Uber driver she knew to see if he was driving. So we can go over and we can verify that was true. 2:10, Uber driver to verify if he was driving. That was true. Ultimately, however, the girls decided to just go to bed. Well, BS. And this is where I go, wait a minute, Judge, did you only look at the evidence provided to you by the state? Or did you happen to take a look at the evidence that the defense provided in response that gave you all the information? Because he is going to absolutely overlook a lot of that. So if the girls decided to just go to bed, then why did you leave out, when you're being as thorough as you can, the fact that EG texted DM confirming he was driving? See, I don't like how the judge leaves out facts in this as he's telling his story. So, and by the way, that is BS, because EG, I assure you, he texted her back that he was driving, and he came and got him, in my humble opinion, from my investigation that I'm about to prove to you here in just a second. Now, this is where you got your notes and your pen out, because this is where it gets real, y'all. And remember, he's getting this information from testimony from DM and BF at the grand jury. At approximately 4 a.m., DM heard strange noises and crying coming from the bathroom. Well, I don't have to tell y'all that if she heard this at approximately 4 a.m., then the car hadn't parked for another 8 minutes. So but this is just the judge's summation right here. There's no facts of anything in this statement. It's just he's really hurting the state's case with this statement. But then you got to pay close attention, because the judge he gives these statements of fact, but he gets them out of order. And the only way to determine that is by going back and forth with this. So this might get a little confusing, but it's straight up facts, I promise you. Follow along. She opened her door at one point and saw a man dressed in black with a ski mask on walking by her bedroom door. She then placed calls and texts to her other roommates to see if they were awake. Only BF, who resided on the ground floor, answered. They spoke once for 24 seconds, during which DM told BF she thought she heard something. So here's where you got to pay really, really close attention, right? Because he starts out by saying she opened her door at one point and saw a man dressed in black with a ski mask on walking by her bedroom door. And then she then placed calls and texts to her other roommates to see if they were awake. And only BF, who resided on the ground floor, answered. They spoke for 24 seconds, during which DM told BF she thought she had heard something. They spoke again a minute later for 41 seconds when DM told BF she saw a man in a ski mask leaving the house. Now, do you see how he got this out of order? Let me show you. Because he starts off with, she opened the door at one point and saw a man dressed in black with a ski mask on walking by her bedroom door. Well, this did not happen before she contacted, according to the judge, BF. I'm going to show you that that's not right either. But she contacted BF. They spoke for 24 seconds, and she told BF she thought she had heard something. So when she contacted BF, she had not opened her door and seen the man dressed in black. She just thought she had heard something. But let me tell you where the judge is absolutely wrong on this. And I'll also show you where what he's wrong about proves our case. It says only BF, who resided on the ground floor, not was in her bedroom, answered, and they spoke once for 24 seconds where she told BF that she had heard something. This is where being really familiar with the evidence comes in. Because when we go over here to these calls, and by the way, he leaves out EG, texting DM, confirming he was driving. He leaves out the fact that Maddie calls Bethany at 2:53, and he shouldn't be leaving out this stuff about Bethany and only doing Dylan because of what I said at the beginning of this video with the present sense impressions and excited utterances and wanting to enter BF into the record the same as DM. So him ignoring all this BF stuff should let you know something. But look at the real-time progression provided by the defense. All right, so EG texts back confirming he was driving. Maddie calls Bethany. And then at 3:51, DM creates a new contact in her phone. Now, we know that's huge, but I got to get you to pay close attention now. After DM creates a new contact in her phone, she doesn't call or text anybody before 4:19:07. And look, she doesn't call BF or text BF. BF calls DM at 4:19:07. So when the judge says she then placed calls and texts to her other roommates to see if they were awake, only BF, who resided on the ground floor, answered. They spoke once for 24 seconds, during which DM told BF she thought she heard something. That's not true, Judge. BF, she didn't place calls and texts to any of the other roommates to see if they were awake before BF called DM, and they spoke for this 24 seconds. So DM hadn't called and texted anybody. BF, where's it at? Right here. BF calls DM. And I know this is the 24-second call because he says they spoke again a minute later for 41 seconds when DM told BF she saw a man in a ski mask leaving the house. So right here at 4:20:28, DM calls BF for 41 seconds. So while the judge is getting the facts wrong, he is inadvertently giving us hard times for what these calls were actually saying. So they testified in the grand jury of what they actually said on these calls. So that is their testimony now. It's locked in. So at 4:19:07, not like the judge says that DM calls everybody and BF's the only one that answers. BF calls DM, and they talked for 24 seconds. Now, what they're saying is during this call, for 24 seconds, DM told BF she thought she heard something. She hasn't seen the man dressed in black with a ski mask. She just told her she thought she heard something. And then they hang up. And then what happens after they hang up? She calls Xana. She calls Kaylee. And look at the times between these calls. At 4:19:07, when BF calls DM, not DM calls BF, and they talk for 24 seconds. So that means she hangs up at 4:19 and 31 seconds. Right here. This is where you need to write this down because this is huge. You need to write down 4:19:07. BF calls DM. They talk for 24 seconds. She then hangs up at 4:19:31. During the call, she tells her that she heard something. So at 4:19:31, she then, I don't know what she does for 29 seconds, but at 4:20, she calls DM. DM calls Xana. Now, that's apparently between 4:20 and 4:20 and 20 seconds. That's about 20 seconds. So she calls Xana and she doesn't get an answer. And then at 4:20 and 20 seconds, she starts to call Kaylee because look, she calls Bethany again 8 seconds later. So this call obviously wasn't able to be completed. So at 4:20 and 20 seconds is when she opens the door. At one point, opens the door and saw a man dressed in black with a ski mask on walking by her bedroom door. Right here. Now, with official times that these calls were made, with testimony about what these calls pertain to from the grand jury, we now know, excuse me, beyond a shadow of a doubt, hard evidence, hard proof that she opened her door and saw the ninja, according to her, at 4:20 and 20 seconds as she's calling Kaylee. Because she hangs up and immediately calls BF and talks for 41 seconds. And this is when she says she saw the guy with the ninja mask. So now we've got these things locked in stone, folks. This isn't speculation. This isn't estimating. It's locked in stone. She saw the ninja guy at 4:20 and 20 seconds. So now you've got to stop and think. She said that when she saw Ninja Guy, he was standing 3 feet from her, staring her in her eyes. And then what does she say in her grand jury testimony? Walking by her bedroom door. So that means in the house, which it's like this, you have DM's bedroom right here. And DM's opening the door and she sees the guy coming down this way and he's 3 feet from her. So he's right here and he's walking towards the back door. At 4:20 now, we know down to the second, 4:20 and 20 seconds. 4:20 and 20 seconds is when he walks past her right here. So that means he's then got to go to the back sliding glass door, out the door, through the yard, up the little hill, all the way up to his car. If we give him the benefit of the doubt that his car is parked just on a straight, direct line, the fastest way to it, I've already used a calculating tool. That's 60 feet. So at 4:20 and 20 seconds, he's right here. And he's got to go from here to here is 60 feet. Through the kitchen, out the back slider, then 60 feet to the car. He's got to open the car door, get in the car, put his key in the ignition, start the car before he even drives off. Now we're about to prove that all this right here that they're saying could not have happened. And once again, this is not based off of estimation or anything, assumptions. This is based off of the FBI's exhaustive report on the movements of the vehicle. And when you take that exhaustive report and you take the fastest time where the FBI seen the headlights of the vehicle coming around Queen Road, shining on the house on King Road or Queen Road, whatever, when the vehicle comes around right here, the fastest time and all the passes that they gauged was the vehicle got from right here to right here where it was caught on camera. The fastest time it had clocked was 49 seconds in all those passes. So even if he was speeding a little bit faster, 49 seconds is our gauge. Folks, According to the FBI exhaustive report, the vehicle caught leaving out of the King Road residence was at 4:20 and 47 seconds. When she seen the guy, according to her, in the house, staring at her walking by at 4:20 and 20 seconds, that means the person would have to go through the kitchen, out the back door, 60 feet through the brush, up the hill, open the car door, get in, start the car, and then drive what takes 49 seconds to drive, all in 27 seconds. It's impossible. They just proved that it did not happen the way that it happened. But not only that, by proving it didn't happen the way that it happened, there's no way to manipulate it because they're basing it off of the timed calls. So there's no wiggle room on this. There's no wiggle this way, wiggle that way. It's hard facts. Now, those calls were made, and I'm sure those conversations happened, but there's only one way that those conversations could have happened. And it certainly wasn't her opening the door in the bedroom and seeing something. The only way that could happen, where the vehicle could get from here to here in 27 seconds, is if she made that call as she's pulling in and she sees somebody getting into a vehicle and then pulling out. That's the only way it can happen in 27 seconds. The way that they're saying it happened, it's factually impossible now. The state's case will be impeached as it relates to the roommates, and there's no way around it. This is the end right here. Now, everybody wants receipts, and I want to make sure I provide everyone in this video. This is out of the judge's ruling on bushy eyebrows, and you can see that it says, DM stated the male was approximately 3 feet from where she was standing, but added that could be off. I obviously probably still a little bit drunk. I just woke up. I don't fully remember. She reiterated, I know he looked at me because I could see his eyebrows, I think I just saw one eyebrow. I don't know why or how. That verifies that he was 3 feet from her and where he was at 4:20 and 20 seconds. Here's the receipt from the FBI exhaustive report. You can see at 3:39:35, headlights briefly shine on the upper exterior of 1127 King Road, indicating a vehicle turning north on Queen Road from the southern parking area of 500 Queen Road. And then at 3:40 and 24 seconds, a vehicle matching the description of Vehicle 1 is seen traveling west on Queen Road, turning north onto King Road. Headlights can be seen shining on the trees to the west of the intersection of King Road and Taylor Avenue, indicating the vehicle turned west onto Taylor Avenue. So 3:39 and 35 seconds, 3:40 and 24 seconds, that's 49 seconds from the time it turns onto the side road by the King Road residence to the time it's caught on video at 1112 King Road. 49 seconds is how long that takes. Final receipt is a vehicle matching the description of Vehicle 1 travels westbound on Queen Road at a high rate of speed, turning north onto King Road. Headlights can be seen shining on the trees to the west of the intersection of King Road and Taylor Avenue, indicating the vehicle turned west onto Taylor Avenue. So 4:20 and 47 seconds is when the vehicle's caught on camera at 1112 King Road for the last time. There are your receipts. Now, when you heard the defense say in a hearing a long time ago, Judge, don't think 7 minutes don't matter. Well, how much of an understatement was that? Judge, don't think 7 minutes won't matter. Don't think a minute doesn't matter when you're assessing reality from fiction. And we now know the proven, no way to get around reality of what we just discussed in this video. It is amazing that it takes that much time to get the information out to where somebody can actually put a calculator to it and prove it is a lie like we just did. But this one is too important for me to just gloss over. So I'm going to give you one more run over on this, and I'm going to make it a lot less confusing than the judge did. I think inadvertently, he just doesn't know. But I want to make sure everybody clearly understands, because we got to get this information out there. I mean, this information needs to be broadcast on a mainstream channel, not just little Pavarotti's channel. It's too big. All right, so it's very important we get this right, and this is how difficult it is to get facts straight in this case. This is factually how this should have been written by the judge, but it's okay because he gave us the facts with the grand jury statements that related to the times of the calls that were made, that lets us know exactly what the facts are. And it starts again with only BF, who resided on the ground floor, answered, which that's incorrect. BF called DM. They spoke once for 24 seconds, during which DM told BF she thought she heard something. And that call was at 4:19 and 7 seconds. And actually BF calls DM. So 4:19 and 7 seconds, they talked for 24 seconds. So they concluded that call at 4:19 and 31 seconds. And again, the grand jury testimony is that call said that she told her that she thought she had heard something. No changing it now. It's grand jury testified. She then placed calls and texts to her other roommates to see if they were awake. At 4:20, she calls Xana. At 4:20 and 20 seconds, she begins to call Kaylee. But she opened her door at one point right here and saw a man dressed in black with a ski mask on walking by her bedroom door right here at 4:20 and 20 seconds. She sees as the prosecution wants to claim, a double-bladed ninja. They spoke again a minute later for 41 seconds when DM told BF she saw a man in a ski mask leaving the house. 4:20 and 28 seconds is when DM calls BF for 41 seconds. Those are the facts. This is when she saw Ninja Guy in front of her door in the King Road residence. And 27 seconds later, on 1112 King Road, the vehicle spotted on camera turning right. 27 seconds later, bye-bye state's case. It is impossible physically. Physics cannot line up right for you. And it's a good thing we discovered this, because you won't believe what else the state was going to try to claim in a rebuttal of one of the defense's expert witnesses. Yeah, that's right. The defense has its own pathologist that's going to testify that the wounds are different on the victims, that two different weapons at least were used. Also, that Xana and Ethan were attacked at the same time. And the defense's expert on crime scene recreation was going to testify to that fact as well. And the prosecution, almost acknowledging that it's true, has got an expert that is going to testify that BRYAN KOHBERGER would be capable of committing all four unalivings with two different unaliving weapons inside of 2 to 4 minutes. That is what they were going to claim. So now BRYAN KOHBERGER is not only dressed like a ninja, he's got two ninja knives, and he commits this atrocity inside of 2 to 4 minutes. And he is so well versed in ninja abilities that he's able to take out Xana and Ethan at the same time with those two weapons. The state is claiming BRYAN KOHBERGER is literally a ninja. I went through great efforts to make sure that this video was as accurate as it ever possibly could be, and you can rest assured it is. This video proves that what the state's witnesses say happened could not have happened. Folks, you need to get this one out. They can put this one under any microscope they want, tear it apart any way they want to. But if they're looking at the facts, there's no other conclusion they can come to. This one actually does prove that the state's case is a lie. Get it out there. Please like and subscribe to the channel. Post your comments, thoughts, criticisms. I got so much more to bring you, but this is the only one today. Pavarotti's out.
Oh, gonna give it a shot. Only one of me to shield you all from the enemy. You're a superhero. You're a superhero.